students, I welcome you all to Clat lecture series, lecture number 1 of criminal law. Okay, criminal law. In this, what we are going to do is we are going to study the criminal basic concepts of the criminal law adjudication system in India, and that is a very key subject for the Clat examination. These classes are sponsored by Sri Jendra Rank Zone, and I am your mentor, Shekhar Gehlot. These classes are going to be a lot interesting. Why? Because we all watch a lot of serials, a lot of movies, okay, and we do read newspapers and a lot. Almost 75% of the stuff is full of crime. So naturally, we are much more inclined to find crime and its disposal and its how the society deals with it, how the judges deal with it, okay, and what is the law for it. A very interesting topic, okay. So, criminal law basic concepts. You may be able to see a kind of what do I call it, a mark chart or a flow chart here, which tells you how a crime is committed or how a crime is tackled within India. Okay, first of all, a crime is committed. Okay, whenever someone commits a crime, what is a crime? Okay, this chart says crime is a wrongful act. Okay, so any act which is wrongful. Okay, and what acts become wrongful? Acts prohibited by the law. Acts prohibited by the law. They are the wrongful acts. If you commit them, you commit a crime. So, what will happen when one commits a crime? He gets caught up, and then there is a prosecution against that particular offender. He is called offender. Okay, the one who commits a crime is known as an offender or accused. Okay, and the prosecution is trial of an accused before the court of law. Okay, so you must have seen some movies which have a lot of lawyering angle to it. Okay, so whatever is happening in the movie in regard to a person, that is called trial. Okay, and when trial happens for a criminal action, okay, trial happens in two type of cases, one is civil, one is criminal. So in the criminal law, whenever trial happens, that is called prosecution, and it is always led by the state. Okay, and after prosecution, the criminal is punished. This is the stage of the criminal law. Okay, this is the stage of the application of the criminal law. How criminal law is applied in India? You commit a crime, crime is prohibited, then prosecution is there against you, and then finally you are punished. Okay, and you are punished adequately. Okay, every crime deserves to be punished. Every crime deserves to be punished. Okay, but the key issue is what should be the punishment? What should be the punishment for a crime? Okay, because there are so many kind of crimes. Okay, if I tell you about Indian Penal Code, it alone has around 200 offenses, 200 type of offenses which a person in India can commit. Okay, can be caught for committing, and there are so many other acts are as well there, like NDPS Act. Okay, Scheduled Castes and Scheduled Tribes Protection Act, and Protection of Civil Liberties Act, and so many other acts are there which also prohibit certain kind of acts, humanly acts, as crimes, and you punish them for them. Okay, so there are so many actions which are prohibited or which are classified as crime. And as a part of society, there are criminals as well. They commit crimes. Okay, and we have to punish them as well. But how do we punish them? What should be the punishment? Okay, in order to understand what should be the punishment or how punishment has to be administered, this brings us to our first part of the chapter, that is theories of punishment. Okay, theories of punishment. First theory of punishment is preventive disablement. This word preventive means stopping something from happening, stopping an event from happening. Okay, what is preventing? You are just preventing something from happening. Like there's a right now a lot of discussion in India how to prevent corona. So what we are trying to do is we are trying to put an end to the further spread of coronavirus. So preventive means preventive theory, preventive disablement theory means first of all we are trying to stop something from happening. And what we are trying to stop something from happening? What is that event? That event is happening of a crime. Okay, we are designing our punishments. This is a design of a punishment. We are designing a punishment in such a way that it results in stoppage of happening of crimes. Okay, stoppage of an event. And what is that event? That event is a crime or disablement. Disabling something. Okay, disabling something means incapacitating an event person. You are incapacitating a person or you are incapacitating an event from happening. Because a crime is always a result of a human activity. So when you incapacitate a human from conducting an act or committing an event which will be categorized as an offense or a crime. So this disablement theory of punishment, this design says you disable a criminal from committing an act. You disable him. Okay. You disable a criminal from committing a crime in the society, and by disabling the criminal, you are going to prevent the crimes from happening. Okay. This is the preventive disablement theory. You read it and then we will discuss it. This theory has used a restraint that an offender, if repeats the criminal act, is culpable for death, exile, or imprisonment. The theory gets its importance from the notion that society must be protected from criminals, thus, the punishment here is for solidarity and defense. The modern criminologists saw the preventive theory from a different view. They first realized that the social and economic forces should be removed from the society. Also, one must pay attention to individuals who show anti-social behavior. This is because of psychology and biological handicaps. Okay, so they are saying this theory says that you disable a criminal in such a manner that tomorrow he is not able to commit a crime. He is not able to commit a crime. Obviously, if society is made free of criminals, if all criminals are gathered and they are isolated from the society, probably the crime rate is coming down by a huge number. Okay, but how do we do that? How do we disable a criminal? Okay, so disabling a criminal, they say, how do you disable a criminal? You execute him. Okay, you send him to death, you execute him, exile him. Okay, banishment, that is called banishment. You send him off the land, you deport him. Okay, you put him out of the boundaries of the state. This used to be a kind of punishment which used to be imposed by kings or monarchs. Okay, but in civil societies this kind of punishment is no longer applicable. Exile or imprisonment, these are the two most desirable kind of disablements available under the law. You execute someone, okay. Very recently, the country executed Ajmal Amir Kasab, or the rapist of Nirbhaya. They were executed. What we are doing? We are disabling criminal elements from socializing in the society or from being in the society by executing them or imprisonment. You put them in the jail. You collect all the individuals who have committed some crimes. Okay, put them behind the bars. Okay, collect all of them and put them behind the bars. This way you are disabling them. When you are in the prison, definitely you are disabled. You cannot move out of your cell. You are locked in a jail. You cannot meet outside people. Outside people cannot meet you. You are being watched 24 into 7. So you are now imprisoned. So when somebody is imprisoned, definitely he is disabled from committing a crime. So this theory says you disable people from committing a crime. And when you disable people from committing a crime, you prevent crimes from happening. You prevent crimes from happening. But how do we understand that who is a criminal? Now they say that we have to look for psychological issues, biological issues. Okay, if someone is having some biological issues or psychological issues, you identify those people. Okay, you identify those kind of criminals who have such kind of behavior. Okay, it is not, this theory is not saying that you identify people and then you put them behind the bars. No, it is not the import of this theory. This theory says when a crime is committed, okay, suppose in particular year 100 criminals have committed crime, you understand the psychology of each criminal. If you find that out of those 100, 20 criminals are having a criminal psychology, or their psychology is such that if they are left free, they will commit again another crime, or their biological upbringing or their biological tuning is such that they are going to commit a crime. This is a disputed area. Okay, this is a very gray area, but it's okay because state applies it, so we have to read it as well. Okay, so you identify them and you give them a strict punishment, and you can treat other 80 with lenient. Okay, with lenient view. Okay, this is the preventive disablement of the society. So, first theory of punishment is preventive disablement. The ultimate object of the preventive theory of the punishment, or the preventive disablement theory of the punishment, is you disable the crime. Sorry, you disable the criminal from entering into the society or from being a part of the society. And by doing that, what you are ultimately doing is you are ultimately preventing the crimes from happening in the society. You take criminals out, crime will automatically come down. Okay, you put restraint on the freedom of the criminals and incapacitate them by putting them behind the bars. Then we go to our next theory of punishment. These are the theories of punishment from where our criminal law derives its knowledge as to how we should adequately punish people. Okay, and what should be the contours, what should be the dimensions of the punishment, what kind of punishment should be rendered to people. Okay, now this is a retribution theory. You read it and then we will begin the discussion within a minute. Retribution. Quid Quid pro quo concept of punishment. Quid pro quo means return the favor, return the action. Okay, favor is a positive word. Return the action. An eye for an eye type thing. An eye for an eye type thing. Okay. A gouged B's left eye. A ghost, B's left eye. Now society says B must, or let us say, puncture. Now B must puncture A's eye. Okay. An action or sorry, a reaction for the action. Okay. If A has taken B's eyes out, then the justice society says the adequate punishment for justice is that B should be allowed to take the A's eyes out. Someone kills me, my brother should be allowed to kill him. This is what this retribution theory is. Equal for equal, exactly equal kind of justice, what they are saying. An eye for an eye. Okay, an eye for an eye. Retribution is the most ancient justification for punishment. This is most ancient because it used to happen only in the earlier medieval era. Now, in the time of civil society, we do not follow such kind of practices. We do not follow retribution theory. Okay, retribution theory much as a theory of punishment, but this has been for a long time a good theory of punishment which kings and monarchs followed. Okay, but now it has lost its relevance in the civil society. This theory insists that a person deserves punishment as he has done a wrongful deed. A person deserves the punishment because he has done a wrongful deed. Fair. Also, this theory signifies that no person shall be arrested unless that person has broken the law. No person shall be arrested unless that person has broken the law. Here are the conditions where a person is considered as an offender. Okay, these are the conditions in which a person is considered as an offender. The penalty given will be equivalent to the grievance caused to the person. The penalty given, okay, the punishment inflicted to be inflicted upon the offender shall be equal to the grievance caused by the person. An eye for an eye. Okay, you chop my hand, I'll chop your hand. You cut my leg, I'll cut your leg. Okay, you break my house, I'll break your house. It is like this. Performed a crime of certain culpability. Somebody performed a crime, definitely. That similar person have been imposed for similar offenses. That a similar person has done a similar kind of offense previously as well. Okay, now suppose that in this example A punctured B's eye. That means A has already punctured somebody else's eye as well in the past. A is now kind of a habitual in puncturing people's eye. That the action performed was by him and he was only responsible for it. Also, he had full knowledge of the penalty systems and possible consequences. That he was a well aware person. He knew what I am going to do because he has done that in the past as well. He knew that what he is going to do will have a repercussions, will have possible legal consequences, and he still went forward with it. With knowing all this, still he committed a crime. That means he does not have any kind of respect, regard, or fear of the state. He is completely fearless person. He has now become a kind of animal. We cannot let animal roam around in the society in that way. So if you have punctured B's eye, we'll puncture your eye. This is a kind of judgment, or you can call it a mob justice. Okay, this is kind of a justice which mob follows nowadays. Mob justice. You must have seen mobs nowadays on the TV sets on the or must have read about them on the newspapers that a huge mob gathered somewhere and they did the justice with the person. They killed him on the spot, or they did this, or they burned them alive, or other things. So you may see the criminal organization. Terrorist organizations, they are following these kind of punishments nowadays. Okay, because they are based upon the ancient beliefs, so they are following ancient punishments. Okay, and they are trying to instill a terror in people as well by following this kind of punishment, that if you dare to speak against us, you will be killed by stoning, or you will be hanged, or this and that. Okay, so the retribution theory is usually for creating a terror in the public. This is retribution. Okay, it has twofold purpose. They are trying to do the justice, whatever suits best to them. That if you have taken somebody's eye, we'll take your eye. But at the same time, they are instilling a sense of terror in the rest of the society. Okay, they are creating a sense of uneasiness and a terror in the rest of the society. Okay, that even if I accidentally puncture somebody's eye tomorrow, and if I am not able to tell that it was an accident, they are going to puncture my eye. So people are going to be terrorized by such kind of theories of justice. So retribution theory is not a very good theory, and it is good that we have left it, we don't follow it much. Next theory is theory of deterrence. Okay, to deter crime from society and instill fear. Okay, this theory of deterrence has dual purpose. It is deterring people from committing crime. But how do you deter? Deter means threat people. Okay, threat, causing a fear in the minds of the criminals who could commit the crime or supposed criminals. You are imposing a fear, you are giving a threat, a warning to all the people who think that they want to commit a crime or they can commit a crime. Okay, and this way, by instilling the fear, by threatening, by warning, okay, you are deterring the crime from happening. Okay, so you deter the crime from happening by instilling fear in the minds of people. You cause them to be afraid of the law. That if you do something wrong, law will take care of it. And then they are afraid in committing such crime. That is how we deter or prevent the crime from happening. This is the deterrence theory. This is very much applicable nowadays. Okay, deterrence theory is very applicable nowadays. Deterrence theory as well as this preventive disablement theory. Both kind of theories are very heavily followed by almost all judicial systems in the world. Okay, people are being put behind the bars every day, and they are executed as well by the state when they have committed something which is rarest of rare offense. And deterrence laws are designed in such a way that when someone comes to know that upon committing a crime, this is going to be the punishment, that he should be afraid. He should feel like, no, I do not want this kind of punishment. Then only there will be a deterrence from the crime, otherwise, not. The retributive theory assumes that the punishment is given only for the sake of it. Okay, the retributive theory feels that we are giving punishment only because someone has committed a crime. Okay, the main plank for the retribution is because A has committed a crime, now B will act accordingly. Okay, but deterrence theory says that we don't have to act only when a crime is committed, we have to act proactively. We have to act even before the crime has happened. We have to stop crime from happening. How do you stop crime from happening? That is the deterrence theory. You create a fear, you create a terror of law. Okay, but that has to be a reasonable terror. It cannot be the kind of terror which is being created by retribution theory, as it is very unjust. Thus, it suggests that evil should be returned for evil without taking into consideration any consequences. Okay. any consequences. There are two theories in which this theory can be divided further. They are specific deterrence and they are general deterrence. They are specific deterrence and they are general deterrence. Anyhow, specific in general, these sub classifications are not part of syllabus, so we can leave them here. It's okay, but let's read it. In specific deterrence, punishment is designed such that it can educate the criminals. Okay, so specific deterrence, the punishment is designed in such a manner that it will educate the criminals, it will make criminals more aware. Okay, thus, this can reform the criminal that are subject to this theory. This can change the criminals. Okay, you are trying to change the behavior pattern of criminals or the thought process of a criminal. Also, it is maintained that the punishment reforms in the criminal. This is done by creating a fear of punishment that will be repeated. So, what happens in the deterrence theory? I tell you, there are so many offenses in the IPC which have punishment like this. Suppose I commit crime A. For the first time, I'll be punished with simple fine. Like we have traffic violations. First time I'll be punished with a simple fine. Then 6 months jail on the second occasion. If I still commit the crime on the third occasion, 3 years jail. And so on like this. So you have created slabs. Okay. So when you have committed something for the first time, you are let off with a fine only. That we are issuing you a warning. It's 4 o'clock. It's a warning. We are issuing you a warning. This fine is a warning. Next time you will be 6 months behind the bars. When you have done it for the next time, you are behind 6 months. Then the next time you are going to be 3 years in the jail. So it depends. You still want to commit the crime, you lose your free time. Okay, so this is kind of, we are trying to educate criminals. Okay, while a general deterrence is designed to avoid future crime. So this is done by making an example of each defendant. Thus, it frightens the citizens not to do what the defendant did. So we are trying to create an example so that other people do not repeat it. We take some criminal who has committed a very ghastly act and we punish him so severely that it becomes an example for the society, like Ajmal Amir Kasab. Okay, hanged till death. So he was hanged till death. The maximum possible penalty in the law was prescribed to him. Why? Because he had committed a very heinous offense. So we chose him to punish adequately as well as to send an example to the society. We set an example for the society that if you tomorrow do something like what Ajmal Amir Kasab had done, then you too shall be hanged to death. Or Nirbhaya rapist have been hanged. It's a message to the society at large that in India we do not tolerate rape at all, and if you are going to be a rapist, we are definitely going to take very strict action against you. This is how you are trying to create a fear in the minds of coming or minds of people who have potential thought process of becoming a criminal, from deterring them, and then at the same time you are educating them as well by giving them small penalties on the first occasion or second occasion and taking strict measures on later occasions when they repeat their crime. Reformation. Reformation comes out of the word reforms. Reforms means bringing positive changes. Okay, that means by reformative approach of punishment, the law is thinking about inflicting a punishment which gives you a chance to change as well, which not only punishes you adequately but also makes you a better human being than you were earlier. Okay, than you were earlier. It has a concept of rehabilitation. Okay, rehabilitation concept as well, making a person adaptable to the society again. Okay, making the person adaptable to the society again. Deterrence and retributive are examples of classical and non classical philosophies. The reformative theory was born out of the positive theory, that the focal point of crime is positive thinking. That if crime has been committed, still we should be positive. We should still be positive. We should not condemn the criminal in such a manner that tomorrow he has no hopes at all, even if he comes out of the jail after completing his whole jail term. After completion of his punishment, when he comes out of the jail, then there should be not such a situation that there is no hope for such an individual. Okay, this theory focuses on rehabilitation so that the criminals who have now completed their penalty and now have no case against them, they can be absorbed in the society. Society can accept them as part of the society and they can have jobs, they can have families, and so on. Thus, according to this theory, the objective of punishment needs to be reformation of the offender. So, this theory says that punishment should have dual purpose. This theory, reformation theory, says punishment must have dual purpose. What are those dual purpose? First is adequately punishing for the crime, then arranging the rehabilitation of offender. Now suppose A commits an offense. A commits and is sentenced for 10 years jail. Now A is sentenced for 10 years jail term. A has committed some offense. It is decided that he should now go behind the bars for 10 years. Now definitely when the 10 years would be complete, definitely someday 10 years would pass by. Okay, and ultimately this man would complete his sentence. And after completing this sentence, he would be a free man one day. But will the society accept him? Okay, will the society accept him or will the society still see him as a criminal? See, this man A, he committed a crime and he was sentenced for 10 years. So he committed a crime 10 years ago. Okay, 10 years back he had committed a crime and he was sentenced for 10 years. Now after 10 years, he has come out. Now he is a fresh man. You cannot judge a man with what he did 10 years ago. Okay, 10 years ago he committed an offense, now he is out. Now will the society accept this man? Okay, so the general answer is no. Society still sees this man as a criminal only. Someone who has come from the jail does not hold a good reputation. People do not accept him. So now here comes the reformation theory that we have to rehabilitate them. State has to facilitate in employment ventures. State has to facilitate them in employment venture during their jail time. They are educated, vocational trainings like cooking, weaving of chair, or some industrial trainings of plumbing, car repairing, etc. are provided to them. Okay, so vocational trainings are provided to them so that tomorrow when they go out as a new man, they have something to do. They do not get back to the world of crime. They do not turn this much hopeless. Society should not make them as hopeless that they do not have any avenue to go and they return to the world of crime. No, society should accept them. And for that, so state runs awareness drives as well in the society as well as in the criminals, that please don't go back to the crimes, and also to the society that please don't treat them like a forever criminal. This is the reformation approach. This is a new theory. Okay, this theory is a modern approach, modern theory, which has just gained traction from last 100 years. We have started following it from last 50 to 100 years. So, this is not a punishment virtually, but rather a rehabilitative process. Thus, this process helps in making criminal a good citizen as much as possible. Furthermore, it makes the citizen a meaningful citizen and an upright straight man. Okay, this is what we are trying to achieve from this particular theory of punishment. Then there is last one is multiple theory approach, borrows the positive from all the theories. Now this multiple theory approach is the latest theory, which says, sorry, this is the latest theory which says we will borrow positive from all the four theories. We'll have some portion of deterrence, some portion of reformation, some portion of retribution, okay, and some portion of rehabilitation as well. Okay, so we are trying to gain the positive of all these four theories. Okay, all these four theories we are trying to gain the positive. That is why there is the concept of compensation as well now. When someone commits a crime nowadays, he is not supposed to pay a compensation as well, monetary compensation. Okay, if I commit a crime with someone, court will not only send me behind the bars. Okay, definitely court will send me behind the bars. I will be imprisoned. I will be sent to the jail. But at the same time, there will be a penalty upon me, financial penalty inflicted upon me, in which I will have to pay a compensation to the one who has been a victim of my crime. So, by making a monetary compensation, we are trying to follow the principle of retributive justice. Okay, in the extent possible. Definitely, we as a legal system today cannot say if someone has gouged your eyes, you also go and gouge his eyes out. Okay, no. But if I have taken somebody's eye, okay, so I will be made to pay some compensation so that at least economically, okay, economically, that person can be given some compensation and he could be placed in a better position. And they are making me pay. They are making me pay. That means that is a kind of retribution. And I am being sent behind the bars as well at the same time. So they are putting me in the jail. So when they are putting me in the jail, they are disabling me from committing a crime and they are preventing crime from happening. Further, by doing so, they are deterring other people as well. They are setting an example to the society, okay, that if you do this, the same thing is going to be happen. The same thing will happen to you. You will be put behind the bars. So they are deterring the crimes from happening. Then, when I am in my jail, okay, when I am in my jail term, they are educating me. State is educating me. State is giving me training. Okay, for latest whatever vocations are available. Okay, so they are making me a better human being as well. They are providing me classes on how to be a good human being and sort of stuff. So they are now following all four approaches in one go. Now we move on to the part B of our chapter. This chapter, this whole criminal law syllabus is going to have a lot of chapters. So this is just the part B, which says essential elements of a criminal offense. Okay, what are the essential elements of a criminal offense? If you can recall, we did the class of partnership act, we did a class of LLP, we did a class of companies, tort, and contract, and whatever class we discussed, we always began with the essentials of that particular thing. Okay, we always began with the essentials. So when we began with the tort, we began with the essentials of the tort. When we read the Contract Act, we began with the essentials of the Contract Act. So similarly, when we are beginning with the basics of the criminal law, we must also begin with the essentials of a criminal offense or essentials of a crime. Because in order to classify a given act as a crime, we must know how a crime is to be committed, what actually is a crime, and then only we are able to decide whether someone has committed an offense or not, whether someone is a criminal or not. Okay, without knowing the basics or the essentials of the crime, we may be doing more injustice rather than justice to the society. You read this principle, this is the essential principle. Actus non facitrium nisi mens citria. Okay, this is the basic principle of the criminal adjudication system in India as well as in most of the countries of the world. So, in order to understand the criminal law, this is the crux, this is the gist of crime. Okay, you read it, you read this whole para, and then we will begin our discussion. Actus non facit reum nisi mans sit rea. If you remember, we did a class of legal maxims and legal principle. In that class, we had discussed this particular of the legal maxim. Okay, you can still go back to that class and understand this particular maxim. But meanwhile, we'll begin our discussion here as well. It explains that for any act to be legal in nature, it must be done with the guilty mind. What is guilty? Guilty means punishable. So, any act which we can categorize as an offense must, okay, must be done. It must be done with a punishable mind, with a culpable mind, with a punishable mind or a culpable mind. It must be done. That means if you are trying to classify an act as a criminal act, first of all you have to identify the mind, whether there exists a crime in the mind or not. Okay, see, because human body acts upon the mental inputs. So whatever my mind will tell my body to do, I will do that. Okay. So whether my mind told my body to commit an offense or not. If my mind said so and then my body did, then that is a crime. okay, then that is a crime. Thus, to convict the defendant or the accused, it must be proved that the criminal act was carried out with a criminal intent. Intent means knowledge or desire, a criminal desire. Not only is the act of the accused important, but the intention of the accused to do the specific act is equally important to prove the guilt of the accused. That means not only the physical act, but as well as the mental act is important to understand whether someone has committed a crime or not. Thus, it can be concluded that mere commission of a criminal act or breach of law is not sufficient to constitute a crime. That means merely committing an act, okay, which has resulted into a offense to someone, okay, which has resulted in an offense to someone may not be a crime at all. Okay, I kill someone, but that may not be a crime at all. Okay, that may not be a crime at all. But how killing someone may not be a crime? Okay, how killing someone may not be a crime? That all depends upon my mental state, and we'll understand it. Further, the mens rea is the Latin term for guilty mind. Further, the mens rea is important to understand the severity of crime committed. The essential ingredient is the blameworthy condition of the mind. Its absence can negate the liability. The absence of guilty mind or the mens rea can negate the liability. They say that if there is no guilty mind, I may have committed thousand offenses, but if there was no guilty mind, then I may not have committed even a single offense at all. It may be possible. Okay, it may be possible that I may not have committed a single offense at all, though I have committed thousand offenses, but none of them is a crime. However, the statement without a guilty mind, there is no crime, is subject to certain exceptions, such as strict liability. In the strict liability, it hardly makes a difference whether you wanted to commit an act or not, or it happened without even your control. Then also you will be liable. That is why it is called strict liability. You will be able to find more discussion on the strict liability and absolute liability in the law of torts classes. Under strict liability, it is not necessary to show that a defendant possessed the relevant mens rea for the act committed. Okay, now let's do an example. Now in all these situations there is a central character, that is A, and the opposite person is dying in all the situations. We have four situations at the hand, and the central person A is doing some act which is leading to the death of the other person. Let us take the situation A. A bowls a bouncer, it hits the batsman, and he dies. Now a person has died here. Okay. But is A guilty of killing him? Is A in this case guilty of killing him? Absolutely no. It is a game of sport. Okay. So you are playing the bat and ball cricket game, and you are playing with a leather ball, and he bowled you a bouncer, and that is also a valid delivery. One bouncer per over is allowed per bowler. So he bowled a bouncer, but somehow the bouncer hits the batsman on the forehead, or suppose say on the chest, and he died. So A, can we call A guilty of committing murder in this case? No. Why? Because the act is there. By his action, someone has died, but his mind was not to kill him. His mind was only to bowl. His mental act was to bowl a bouncer, not to kill. But ultimately, he has died. Okay, that is a case of accident. We cannot call it a crime at all. So, in this case, there won't be any penalty upon the A. Okay, why? Because we are punishing the mens rea, we are punishing a guilty mind. A is not having a guilty mind here. Okay, A is not having a punishable mind. Now, situation 2. A stole the food from a person. Later, that person died of hunger. Okay. A stole a food. Okay. And other person died of hunger later. So now in this case, A's action has led to the death of someone else. Okay. So now can we call A guilty of killing other person? Very well, no. The answer is no. Okay. The A could be accused, A could be guilty of stealing. A could be guilty of stealing, but definitely A could not be guilty of killing her, killing the other person. Okay, because he committed the act. His committed was his act, his mental state or mental action was to steal. It was not to kill. But ultimately, this man died because he had no food other than what this person stole. Okay, but still no murder. Why? Because his action may have led to the death, but his mental intention was to steal. A hits someone with a car and that person dies. Okay, so A is driving on the street. Okay, and suddenly a biker comes out of nowhere, hits his car, and there's a collision, and in that, ultimately, the other person dies. Now, due to his action, or suppose say A is driving rashly, and due to his action, someone dies. Now, do we hold A guilty of committing a murder? He is driving rashly. Okay, he is driving rashly, but do we find him guilty of the murder? Answer is no. Why? Because he is guilty of driving rashly, but he never thought that I will kill someone. His only thought was to drive fast. Okay, and driving fast is dangerous, but he drove fast. So his only offense here is to drive fast. It may have led to the death of someone, but that his offense only is of driving fast because only his act led to the death, not because of his mental choice. It was not that he killed someone by choice or by thought process. Now let us take the next example, that is A shoots a person in chest and that person dies. Now when you shoot someone, you know that a bullet can kill someone. So when you are shooting someone, that too in the chest, or that too in the chest where the heart is, which is a very sensible area, okay, then you hit him in the chest. That means now you are trying to kill that man. So in this case, you wanted to kill that person and that person is dead. So now you are guilty of committing the murder. Okay. Not because your actions have led to the death. Okay. But because you also wanted, mentally you wanted, your mind said that you should kill him, and then you killed him. Okay, it is not merely a physical act which has resulted into a death, it is also a mental act, okay, which has brought the death of this other person. That is why he died. So this is the relevance of mens rea and actus rea. You can be guilty only and only if what you have done is what you wanted to do. Okay, but if what you have done is not what you wanted to do, your mind is not guilty, only your act is guilty, then you may not be guilty at all. Okay, this is the principle, this is the salutary principle of mens rea. Okay, the two basic components of the criminal law is actus rea and mens rea. Actus rea means guilty act. Okay, guilty act. Mens rea means guilty mind. Okay, actus reus is the wrongful act committed, and mens rea is the state of mind behind such act. The Latin maxim actus non facit reum nisi mens sit rea is derived from mens rea. Actus non facit reum nisi mens sit rea further explains as to how mens rea is applicable in the criminal law. It states that a person is guilty of a criminal activity only if such acts are accompanied by a criminal intention, like we just discussed. This maxim is used to determine whether an act committed is a criminal in nature or not. Okay, this maxim is used to understand whether the act is criminal in nature or not. Severe penal actions are required for crimes committed with specific intent, and not for unanticipated or unintentional acts. So the acts which are unanticipated or unintentional, just like accident, are not penal. No severe penalties are there for acts which are unintentional. However, no breach of law can be left unpunished. Thus, this maxim established to differentiate between intentional and unintentional criminal acts so that the quantum of punishment can be decided accordingly. Okay, so the quantum of punishment, that how much we should sentence someone, shall be decided accordingly upon the mental statement. Okay, so in this case, definitely he will be punished, but he will be punished only for stealing. He will be punished only for driving rashly. He will not be punished at all. Okay, he will not be punished at all, because that is a case of pure accident, and an accident is an accident. You cannot find someone guilty for an accident. Okay, you may say that in this case also this is an accident, but this case he is actually driving rashly. Okay, so when you drive rash, you know that accident may happen. So somehow you had a knowledge that some unfortunate accident may happen. But in this case, when he bowls a bouncer is, I mean, it's a rarity that someone gets killed by a bouncer. Okay, so he does not know that bouncer is going to kill. Bouncer is only to threat or disturb the batsman. That's it. He's shooting a person in chest. He definitely knows that his act can kill. So he is definitely guilty for committing the murder, otherwise not. Actus rea is the physical element. Like we discussed, mens rea is the mental element. Actus rea is the physical element. Legal distinction between act and omission. Okay. Now actus rea can be of two types. Act can be of two types. A positive act, like you are doing something, or an omission, where you fail to do something. Okay, you were required to do something, but you failed in doing that. So that is omission. That is called omission. Not doing something is also an omission. It becomes a negative act. And the positive act is you actually did something. That is a positive act. An act forbidden by law. Omission can be actus reus. An act forbidden by law and an omission which is forbidden by law, both can be actus reus. Both can be physical element of a crime. Omission is a subset of act. All omissions are act, but all act are not omissions. Okay, all omissions are act definitely, because omission is a particular type of activity of not doing something, and then there's a positive activity. So act is a wider term. That is why all omissions are act. Definitely, every omission is an act, but all act are not omissions because positive acts are also there. Person A is drowning. Person A is now drowning in a swimming pool or somewhere. Person B sees and ignores. Now person B sees the person A drowning and he ignores. Person A dies because of drowning. B had a moral duty, but it is not a crime. B in this case has a moral duty. Okay, it is everyone's moral duty to assist each other when in the face of a crime. So, when he sees someone dying due to drowning and he could have saved him, so he should have, but he did not. But he has not committed the crime because he is not responsible for the first place. Okay, for the place of for that person A to be drowning, he is not responsible for it. He is only responsible for not attempting to save him. Okay, but that is his choice. Okay, it is his moral duty. It is his moral duty. Just like when I see someone trying to shoot someone and I run towards the shooter in order to catch him, but that is only my moral duty. Okay, I cannot risk my life. So we cannot expect B to risk his own life to save someone else's life. It is his choice. If he chooses to do so, he is a hero. If he does not choose to do so and the other person dies, he has not committed a crime. Okay. Another case is B had a legal duty and here there is an omission. Now B was a lifeguard. Okay, B was a lifeguard or a life coach outside the swimming pool and he sees someone dying and he is specially trained for saving people from drowning and he is put for that duty as well, but he does not do anything. So in that case, that is called omission. Okay, he has not done anything. The person went to the swimming pool, now he does not know swimming and he is dying. But now he had a duty. He had a duty to save him or to help him in any case, but he did not do so. So his not doing here will now become a crime. His not doing here will now become a crime. Definitely, again, not the crime of murder, not the crime of killing someone, but definitely a dereliction of duty, not fulfilling the duty. You still cannot hold him guilty for killing someone. Mens rea. Mental element. Mens rea guilty mind is the mental element of a person's intention to commit a crime or knowledge that one's action or lack of action would cause a crime to be committed. It is a necessary element of many crimes. Okay, in almost all crimes, mens rea is a necessary element, and you cannot commit a crime unless there is mens rea involved in that. Okay, so mens rea assumes a great importance here. Now, what are the degrees of mens rea? This diagram, oh sorry, not this diagram, this illustration. Okay, this illustration will tell you different degrees of mens rea. Okay, it is intention, then knowledge, reason to believe, recklessness, negligence. These are the these are types of mens rea or degrees of mens rea. Okay, this is like this is a ascending order. Okay, this arrow is wrong, but this is ascending order. This is the lowermost degree of mens rea. Then this is 1, 2, 3, 4, 5. Okay, that is the topmost, the highest, the gravest degree of mens rea. Okay, this is the intensity of mens rea from down to top. Okay, from down to top, the most severe is at the top, the most less severe is at the bottom. Negligence is a very less serious degree of mens rea, and intention is the highest grade of mens rea available in the law. degree or types of mens rea. First one is intention. Inner mental desire. Okay, that means you want something to happen. Okay, that is your desire, you want it to happen. A person acts purposefully, intentionally, if he acts with the intent that his actions cause a certain result. In other words, the defendant undertakes his action either intending or hoping that a certain result will follow. Okay, he shoots Z expecting Z to die. He has the intention to kill Z. Or A poisons. Okay. A poisons Z's food in order to kill. Z eats the food and dies. Okay. Now A has a intention. His inner desire is that when he's poisoning the food, when he's putting a poison in the food, his inner desire is that Z should have this food, and after having this food, he should die. So now he is having an intention. So when he is doing it intentionally, that is the highest degree of mens rea, guilty mind. He wanted to kill him and he killed him. Okay, that is mens rea. Knowledge is slightly lesser degree of mens rea. A person acts knowingly if he is aware that his conduct will result in certain consequences. In other words, a person acts knowingly if he is aware that it is practically certain that his conduct will cause a specific result. Now, intention is that he wanted to kill Z and he killed Z. That is a certain intention. But the knowledge is somehow different from the intention. Okay, now in this case, A has put a live wire. A has electrocuted the entrance of his house. Okay, A has electrocuted the entrance of his house. A's house is having a mango tree. A's house is having a mango tree which is having fresh ripe mangoes. Okay, and he's troubled by people illegally entering his house, his veranda through his door and plucking the mangoes. He is now troubled that people are stealing my mangoes. So what he does, he puts a live wire. Okay, thinking that if someone will come into contact, he will get electrocuted. He will then not come back. But Z comes in contact and dies. He did not want to kill Z. He only wanted to stop trespassers. But definitely, when he is putting a live wire, he has a knowledge that someone may get killed as well. Someone may get killed as well. Z comes in contact and dies. Now he is not doing anything against Z. He is doing it against anyone else, everyone who wants to come in illegally into my house to pluck my mangoes. Okay, he is wanting to do that, but he has a knowledge that whoever comes in the contact can die as well, and he has a strong reason that someone can die. He has a strong knowledge about it, because we all know electricity can kill. So now he is guilty of committing the death of Z. Why? Because he knows that his act could have done that. Okay, he is aware of his act. That is called knowledge. Okay, intention is when you wanted to kill Z and you killed Z. That is your intention. But your knowledge is you act in such a way that you are aware that your actions can kill someone. Okay, and it killed. But you did not know whom your action will kill. Okay, whom your action will kill. Like, okay, like celebratory firing at marriages and functions. People are firing in the air. Okay, they have a knowledge that if someone gets hit, he can die. So someone gets die. They have a knowledge. So they are now guilty of committing death of someone. Okay, but because this is lesser, this is less degree of knowledge, this is lesser degree of mens rea than this. Thereafter, that means he will get a lesser punishment from this. Okay, when he commits a crime, he will get a severe degree or higher degree of punishment than this person committing a crime. Okay, because they people are committing a crime not because they want to commit a crime. Okay, but they are aware that their actions may cause offense, and still they did that, and offense happened because they had a knowledge but not intention, but knowledge. Okay, then also they are guilty. Okay, recklessness. A person acts recklessly if he is aware of a substantial risk, that a certain risk will occur as a result of his actions. The risk must be substantial enough, and the action represents a gross deviation from what a reasonable law abiding person would do. Now, recklessness is the third degree. Okay, this is the most severe, this is less severe than this, and this is recklessness is lesser severe than knowledge. A is driving in the influence of alcohol. A went to a party, he consumed a lot of liquor there, he got on the driving seat, drove very recklessly, his car jumped the divider and hit the Z who was standing on the road, and Z died at the spot. Now, this is a case of recklessness. Okay, this is a case of recklessness. A is driving in a drunken state. He is not supposed to be driving in a drunken state. This conduct, driving of the vehicle in a drunken state, is not a conduct which a reasonable law-abiding person would do. Okay, so what he has done is his act is reckless. He certainly did not want to commit this accident. He certainly did not want to kill Z. Okay, but his act is so reckless. Okay, and he was aware that if he is driving, some accident can happen, but he did not know what kind of accident. Will it be a normal accident in which some vehicle is going to be damaged, or he alone is going to be damaged by hitting a tree, or will it be an accident and that someone like Z will die? Okay, definitely he was hoping that he will go reach home safely. But still, he had some knowledge. He had some knowledge that my act is reckless. Something bad may happen, but he definitely did not wanted this to happen. Okay, and his action are less severe than his action. Here, this man, he's playing with the fire by doing celebratory firing. He's firing here and there, okay, without taking care of all the measures. And then this person, he's putting a live wire. They all know that bad consequences may happen, but here he knows that bad consequences may happen, but his bad consequences are not as certain as theirs are, and his bad consequences can have different degrees, ranging from a very mild accident, ranging from no accident at all to mild and to serious and then to very grave, in which someone may die. Okay, so this person will get lesser punishment than this person. Okay, because we punish mens rea. Okay, law punishes mens rea. We punish mens rea. Okay, not act only. We don't punish only act, we punish act which is with guilty mind. So this is the highest grade of guilty mind, so it will get the serious, most severe punishment. I'll write. A person acts recklessly if he is aware of a substantial risk that a certain result will occur. This is a repetition, I should remove it. Now we go on to negligence, which is the least severe degree of mens rea or guilty mind or intention. A person acts negligently if they should have been aware of a substantial or unjustifiable risk that a certain consequences would result from their actions. Okay, a person acts negligently when he is doing something which he should not do. Okay, okay, when he is doing something where he is aware that something bad may happen, but he still did not take care of it. Although the level of risk is same for both recklessness and negligence, the difference between the two is that with recklessness, the actor must be aware of the risk involved with their actions, whereas for negligence, the actor is not aware of the risk but should have known that those risks were. Okay. In other words, where Rita sets a bomb, this is a nasty example. Okay, we'll do a better example. Okay, in this case, A is a person who has been commissioned to dig up a borewell. He digs a 50-meter deep borewell and then leaves it uncovered there. A small child comes playing, falls in the ditch and dies. Now, this is a kind of negligent act. This act is a negligent act. Okay, where he should be aware of his consequences of his act, but he is negligent. Okay, he is negligent. Or okay, here A is cutting a tree from the trunk. So after the tree is half cut, okay, after the tree is partially cut from the trunk, A takes a tea break, goes to take the tea. But he does not realize that winds are heavy. Winds were heavy and the half cut tree could not sustain itself and it fell down automatically upon Z and Z dies. Now this is a case of negligence. He did definitely not want to kill Z. He definitely did not want the tree to fall. Or the other person definitely did not want the kid to jump in the borewell. But all these things happened because they had been negligent in their duties. If they were not negligent, if they were vigilant, the he would have covered the borewell sufficiently, or A would not have taken a tree break on such a crucial time when the tree was half cut. Doctrine of transfer of malice. Transfer of motive. A intended to kill B and ended up killing Z. Although never intended to kill Z, but due to complete intention to kill B, A is liable for death of Z. Now, doctrine of transfer of malice says that sometimes it may happen. A goes to kill Z and he shoots. But somehow Z's wife, Y, who is also standing with Z, comes in between and the bullet hits Y and she dies. Z did not die. Now A is caught up. Okay. Now A says to the court that I have committed no offense. Court asks him, why have you committed no offense? How do you say that you have not committed an offense? You shoot a person dead. He says, the law punishes only a guilty intention. Okay, my intention was to kill Z, but Z is still alive and Y has died. My intention was not to kill Y. Okay, I did not have any intention to kill Y. So this should be treated as a case of accident, not a case of murder. Okay, case of accident only because I wanted to kill Z. My mens rea was for killing Z. My mens rea was never for killing Y, but still Y came in between and she died. So when I did not intend to kill Y, I did not intend to even hurt Y, and she is dead. So now I should not be guilty because I only due to my actions Y has died, but definitely my mental thought process was not to kill Y, it was to kill Z, and Z is alive, so I have not committed an offense. Okay, that is taken care by this doctrine of transfer of malice. Malice means bad intention. This doctrine says that if you have planned to commit an offense and meanwhile committing an offense, some other person is hurt. Okay, you wanted to hurt someone, you wanted to commit an offense with someone, but somehow the offense happens with any other person. Then you cannot claim that I did not have mental intention to commit harm to that person. Okay, the doctrine of malice will say is when you wanted to commit an offense and somebody else got hurt due to this, we will assume that you had the intention to kill that other person as well. Okay, we will assume that it was your intention to kill that other person as well. That is the doctrine of transfer of malice. Your bad intention was to kill Z, but now we will transfer your bad intention to kill Y. Okay, we will transfer your bad intention to kill Z to bad intention to kill Y. That is doctrine of malice. Transfer of malice. Malice is bad intention. Complicity and joint liability in criminal law. Okay, now we have understood the case of vicarious liability in the law of tort. Okay, when we did law of tort, we did
It's
study
5 o'clock.
about vicarious liability. Vicarious liability means you are holding principal guilty for the acts committed by the agent, even though principal is not aware of it. Okay, and principal has not asked him to do so, but still a crime is committed, and principal is also liable. And also, we did in the case of Partnership Act that a partner is liable for the partner of other acts, other partners act. So, when a partner goes into the market, makes a transaction, other four partners of the firm are not even aware of the decisions being taken by the fifth partner. But whatever decision this fifth partner is taking, okay, it will make all the other four partners liable as well. That is the doctrine of joint liability or vicarious liability. Do we have a do we can we extend this principle to the criminal cases as well? Okay, that means my servant goes and murders someone. Will I be liable for that? Because he is my servant and I am the employer, I am the master. Okay, will a master be guilty for the criminal actions of the servant? Read it and then we will discuss it within a minute or two. So, now what is vicarious liability under criminal law? Let us read. A person can be criminally liable for the acts of another if they are a party to the offense. It says a person can be criminally liable for the acts of another person if they are party to the offense. Only if they are party to the offense. That means if my servant has committed an offense upon my instruction, then only I will be guilty along with my servant. Then only I shall be vicarious liability. It is different from a vicarious liability of a civil case. Okay, in the case of principal agent relationship, a bus driver of a state transport commits an accident, someone dies. Now, the state transport department, being the principal, is liable to compensate, even if they did not want it. They did not want this driver to commit this accident. Okay, in the case of partnership, five partners are there, four are sitting in the office. Fifth goes in the meeting, sorry, fifth goes in the market and makes a transaction. The other four are not even aware that fifth has gone into the market to make a transaction and he makes a transaction and suffers a liability. All five are liable, even if the other four were not at all aware that what other partner is doing. So, in the civil cases, we are extending the principle of the liability on the principal as well as employer or the partner. Even, even if the principal or the other partner or the master is actually not aware of what he is doing, what the servant or the other co-partner is doing, and they are not at all interested in his actions. But in the criminal law, the rule of vicarious liability is somehow more strict. It says the agent can bind the principal with his criminal actions only if the principal was a party to the offense. So, one partner will be guilty for the crimes of another partner if they are a party to the offense, are a if they are playing a part in the offense. Okay, then only, otherwise simply because he is the master or the employer, criminal liability will not automatically transfer in such cases to the principal or the employer. For instance, the driver of the getaway car is guilty of armed robbery of a store, even though the driver never left the car, and the entire robbery itself was committed by the others. Okay, the driver of a getaway car. So, bank robbers enter into bank. Okay, they are looting the bank, they are holding the people on gunpoint, they are threatening, they have killed someone as well. They loot 20, 30, 40 lakh rupees from the bank and then come out of the bank. Okay, they come out of the bank and run towards a car on the which is already being occupied by another friend and he is waiting for the robbers. The moment robbers enter the car, he drives the car and takes the robbers to some safe place. Now all the offense has taken place inside the bank. Okay. The robbing, the killing, the taking out of the gun, the threatening of the cashier, the killing of a woman, the robbing of the bank, the collection of the money, the running, this all offense. It has taken place inside the bank. Now outside what they are doing, they are just trying to escape. Okay, after committing an offense. Now who has helped them in this escape? This person. So now this person becomes party to the offense. Though he has not gone inside the bank. He did not go inside the bank, he did not wage a gun there, he did not kill someone, he did not threat someone, he did not even utter a single word. But because he assisted them, the criminals, in his getaway car to escape from the law enforcement agencies, now he will be vicariously liable for the actions of other criminals. So now he will be liable for what the bank robbers have done. This is the principle of vicarious liability in the criminal law. The essence of vicarious liability in criminal law is that a person may be held liable as the principal offender, that is, the perpetrator of the crime, whose actus reus is physically committed by someone else. That means he, okay, means the person who's vicarious, the principal. See, I am stressing it again. We are not merely punishing a physical act, but we are punishing a physical act which is accompanied by a criminal guilty mind. Okay, so in such cases, we assume that the principle could be understood as the part of guilty mind framework. That means the principle means principal or employer, or means the principal who's being held vicarious liability, or the bank or the car driver, that he was mentally a part of that crime, but the physical acts may be carried out by someone else, but mentally he was the part of the plan, part of the crime. So when the crime is committed, whoever's mind was involved in the crime, whatever act he may have played there, whatever act he may have done there, will be vicariously liable, will be jointly liable as if he has himself committed the offense. A orders Z to kill B. Z kills B. Now A directs the Z to kill B. What he does, he goes and kills B. Now, who has committed the actual offense? Now, Z has committed the B. Okay, it is Z who took out a sword or who took out a gun and killed B. But who ordered the killing? A ordered the killing. So now A becomes the part of the offense committed by the contract killer. Okay. So A wanted to kill B, but his physical action is taken by Z. Okay, his physical activity is done by Z, mental activity is by A. So they both have now committed the offense of killing B. That is the principle of vicarious liability in criminal law, vicarious liability or joint liability. It is believed that person merely performing the act asriya means physical act on the say of another is not innocent and thus is also made liable for the offense. Okay, so both are liable for the offense. Z as well as A. We cannot say Z is innocent just because he was following the direction of A. No one is bound to follow unlawful directions of anyone. Okay, no one is bound to follow illegal directions, illegal orders from any superior at all. But if they are following it, then they cannot say that we were under a command or under a duty of my employer. No, you cannot say that. Nobody is duty bound to commit a offense, neither can someone make other duty bound to commit offense. It is believed, the law sometimes focuses upon the relationship between the defendant, that is accused, and the performer of the physical acts, and by virtue of the relationship, it attributes the act of the latter to former. Okay, the law says the former. Okay, former means the defendant, the principal. Okay, the principal. So the accused has done something only upon the insistence of the principal. So now principal will be liable because of the relationship shared by them. And the mens rea of the guilty mind is actually initiated first of all by the principal, then only defendant or accused come into picture. It should be emphasized at the outset that this form of liability in criminal law is very much an exception rather than a rule. Sorry. It says that this principle of vicarious liability in the criminal law is only a kind of exception, not a general rule. That means it's a rarity. Usually, someone who has committed a crime, only that person will be observed as a guilty of committing a crime, not other people. But sometimes we may make the principal also as a joint person or a joint offender or joint accused, but that shall be exceptional case only. Okay, not a regular manner. The concept of vicarious liability is mainly a civil law principle whereby an employer is made liable for the negligence or breach of the duty of his employees. It is usually not a criminal concept, but it has been imported into the criminal law as well because other person may abuse the lack of the law. Okay, if there is no such law, then any rich person will try to settle the score with his enemy and will pay some money to a poor person who, due to his circumstances, may be willing to carry out a crime. So later on, when he'll be caught, then the rich person who has paid for the commission of the crime will say simply that I may have asked him to do so, but actually the crime has been committed by him. So I am not responsible. Okay, so in order to prevent this from happening, we have this criminal liability in the vicarious liability in the criminal law as well. Now these are the types of criminal vicarious liability. Okay, these are the type of vicarious liability in the criminal law. First one is the common intention. Okay, common means similar. Intention means similar frame of mind, similar guilty mind. So first one is when you are having a guilty mind similar of someone else and a crime is committed, then all those people who share that guilty mind, who share that mind which wants the crime to be committed and the crime is committed, then they all are responsible. Okay, it is applicable especially, sorry, not especially, but only in cases where there are two or more persons. That means minimum person to be guilty. Okay, for common intention, for holding a common intention, is minimum number is two. At least two people are required to hold a common mental intention, and one of them carries out an offense. So that will become a common intention. And when in furtherance of common intention a crime is committed, then each shall be liable as if the act is done by him alone. Okay, each shall be liable as if the act is done by him alone. Let us take an example. Now, in this example, three people A, B, and C they go to house of Z in order to kill Z. Now, they all three have a common intention. Okay, they all three have a common intention. What is the common intention here? Common intention is to kill Z. What role they all play? A stands at the door for preventing Z from escaping. A stands at the door so that if Z is trying to make an escape, he is not allowed to do that. I will stop him. B holds the hands of Z from the back. Okay. And then A stabs Z in the chest as well as stomach. And Z dies. So in this case, A has not done anything. He was just standing on the door. And B has done something, but what he has done is only holding the hands. The actual role is played by C. He takes out the dagger or the knife and stabs Z in the chest and the stomach and he dies. But law will say because you all had a common intention. You all went together to commit a crime and you all had a common intention. The common intention was to kill Z, and because of your common intention, a crime is committed. Then A shall be guilty of committing the murder of Z. B shall be guilty of committing the murder of Z. C shall also be guilty of committing the murder of Z. Law says we will see A also as if a person who has stabbed Z, though A did not do so. Law says we will treat all of you three equally as if the crime was committed by each of you individually. Okay, so that is the case of vicarious liability. In the case of common intention is dealt by section 34. Minimum people to be held guilty under this section are two. At least two people should be there. The essential ingredient of section 34 is meeting of mind. Meeting of mind means there should be a sameness of mind. Now, in this case, let us take another example. Now, this is another example. In this, what has happened? A, B, and C again go to Z's house. But now there is a common intention. Their common intention is to beat him. They all three go with a common intention to the house of Z, and their common intention is to beat him, not to kill him. Meanwhile, when they are beating him, suddenly Z, who has a knife with him, C is carrying a knife with him. But A and B are not aware of this. They do not know that C is also having a knife with him. During the fight, C suddenly takes out the knife and stabs Z in the chest, and the Z dies. Now, in this case, the law cannot hold A and B also for guilty to committing the murder of Z. Law can only hold A and B guilty of forming intention to beat Z, but not of murder. Okay, because they are not aware. And C alone will be tried for committing murder. Because meeting of mind has not happened here in this case. In this case, there is a meeting of mind. They all are going to kill Z. But here they all are going to beat him. And A and B are not even aware that C is having a knife. And then C took out the knife and killed the Z. Though C was able to kill Z only because of the participation of A and B, because there were three in number. A and B provided support. Then only he was able to kill Z. But it is not that they provided him such support so as to take Z's life. They only went there to beat. So when someone is done by C in this manner, then only C alone is liable for murder. Why? Because there is no meeting of minds. The essential is that meeting of minds must be there. That is the common intention. That means you should have a common intention, and you can have a common intention only and only when there will be meeting of minds. Participation is required for common intention. Participation means some positive act. Some positive act is must. Now, in this case, what happened? A, B, and C they all planned to kill Z on 12th, but suddenly on 11th, C alone went to Z's house and kills him. Now, A and B are not guilty at all here. Okay, because some participation is required. Here, they have not done any participation at all. C alone went and killed, though they also had an intention to kill the Z, but they could not participate in the offense. Okay, so participating in the offense is also required to holding someone guilty of liability of actions, criminal actions of other. Minimum participation is required. Participation could be a phone call, or providing someone money, or providing someone equipment, or providing someone with plans, okay, or giving someone money to carry out something. Participation may be anything, but there should be participation, and there should be a link between the role played and the action committed. Here there is a link. A has a role, his role is to secure the door. B has a role, the role of the B is to catch hold of Z, and C has a different role. But here A and B could not play any role at all. They did not participate in the act, they were not even aware. C somehow found Z on 11th only and killed him. Now A and B are not aware of this, though they have a common intention. Their common intention is there to kill Z, but they did not participate in the offense because C alone went and somehow killed Z. So, this is the essentials of common intention, that how common intention should be looked at. Similar intention, not same as common intention, hence not section 34. Okay. Common object, section 149. Here, your intention is common. Okay, you intend to do that thing, but here only the object is common. Intention may or may not be there. Okay, intention may or may not be there, but the object is common. Any member of an unlawful assembly in prosecution of a common object. What are the ingredients of common object? We have done common intention. Now, common object. What are the essentials of the common object? any member of an unlawful assembly. Okay, that means here there has to be an assembly. Assembly means more than two-person again. Two-person. That means at least two-person has to be there, then only we can call it an assembly. Okay, at least two-person should be there. In prosecution of a common object, they all have a common object. Okay, they all have a common object. Mere membership of an unlawful assembly is required. Here, only membership is required. Participation is not required. Meeting of mind is not required. Okay, only object has to be similar. That the assembly gathered there, their object was to do something. So, whoever is the member of that unlawful assembly is liable for that offense. Okay, and for assembly, minimum five people should be there. We call assembly only after five people have gathered. So, minimum five people should be there to become part of unlawful assembly. Or more people, five people or more, can be unlawful assembly if the common object is to show criminal force. If the common object of the assembly, we see 10 people gathered there, we are protesting a law, a new farmer law, and we have a common object. That moment the farmer minister, agriculture minister comes, we will throw stones at him. Okay, we will throw stones at him. We have a common object. Common object is throwing of the stones. Throwing of the stones at the minister in order to teach him lesson. But somehow one stone hits the minister on face and minister dies. Now we all of us are guilty of this offense of killing the minister. Even if someone may have not even picked a stone, they were only standing there. But mere membership, just because you are a member of such kind of assembly, you will be held liable. Okay, just like others. Okay, so any assembly whose object is to show a criminal force, okay, or to exist or to resist the execution of any law. Some law is going to operate, you are going to resist it. To commit mischief or criminal trespass, to commit some nuisance to someone, or to commit criminal trespass. By means, any force, criminal force to any person to take possession of land. These are the offenses, okay? Taking someone's land to compel someone to do something wrong, etc. If five people or more are doing something, okay, and they have a common object, then all of them are liable, even if they did not take part in the offense. Even they did not take part in the offense, here they took at least in common object, sorry, common intention. Participation is required. Here only membership is required, only the membership. Okay, mere membership is sufficient in the case of common object. A, B, C, D, and E, F. A, B, C, D, E, F. They are having common object to kill Z. Okay, all reach police station. All reach. Suppose Z is a police inspector. All reach police station. Okay. F kills the Z. A, B, C, D, E did not do anything. They were standing, he killed him. Okay, they played no role. Now, this time nobody is watching the door, nobody is holding someone's hand, but F alone kills him simply. But because they were part of the unlawful assembly, which had a common object was to kill Z. Okay, and Z is now killed. So mere membership. Here they have not participated. Okay, here they have not participated. Here they were participating. Okay, someone was watching the door, someone was holding hand. Here nobody did anything other than F. He killed the C. Okay, he killed C. That means now, because they are part, mere membership is sufficient to hold someone guilty. Mere membership is sufficient to hold someone guilty of unlawful assembly because they are 5 in number, 6 in number, so it is unlawful. And they have shown a criminal force. So they are now guilty of committing this offense, which is punishable under Common Object, section 149. Now we'll do this comparative in the next class. It is already time for this class. Thank you.